The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning, and a recording will be available later today. We're ready to hear argument in cause number PD-1292-19, Frederick L. Brown versus the state of Texas.
Thank you, Your Honors. May it please the court, Mr. Guy. I'll start by saying we've gotten to the Court of Criminal Appeals by a jury trial where Mr. Brown was found guilty for 2 counts of assault family violence, 1 by impeding breath and blood, and 1 by assault family violence with a prior. The prior was used as a jurisdictional enhancement for 1 count and as a punishment enhancement for another count. I'm not going to touch so much on the testimonial nature of the statements that were made. It's a 6th Amendment question, confrontation clause. So we know in order for that to be the case, we're dealing with testimonial statements. I think that is well stated in the briefs, and I won't waste your time on whether the statements are or are not testimonial. I think it's very clear these are testimonial statements. Moving forward from that, I'd like to start with the genesis of forfeiture by wrongdoing that is now codified in Code of Criminal Procedure 3849. And I'd like us to all remember.
Counsel, is this a statutory interpretation question or a constitutional question about the confrontation clause?
It's a statutory interpretation question because the court got it wrong and did not interpret the statute correctly when they applied the facts to the case. In addition to that, it's a 6th Amendment constitutional question because they did not uphold his 6th Amendment right underneath the Constitution to allow him to confront his witness.
Was there an objection made on the basis of the confrontation clause?
There was, Your Honor. That was the objection. The 6th Amendment confrontation clause issue was the objection made at trial. And that's what got us here today through the Court of Criminal Appeals and the Sixth Court. So the genesis of the forfeiture by wrongdoing doctrine came from the mafia killing its witnesses. So that's where it all kind of generated for the codification of it. Because mafioso killed their witnesses, it was very hard to prosecute them. And in Texas, we codified it under Code of Criminal Procedure 3849. And that requires 2 things: the wrongful procurement by an action of the defendant of the witness's availability in court.
Counsel,
Yes, sir.
Why did the legislature use procurement? What does procurement mean? Like, it's a weird word to be using. I mean, when I think of procurement, I think of going to the store or something. So what does procurement mean? Do we look at precedent with regard to the forfeiture by wrongdoing to understand what that means or not?
I think so, Your Honor. We go to the precedent, and if you look at all the cases, what it has meant is an act by the defendant to keep the witness from being there. That's what all the cases have said. It says by the design. One of the cases says designed to keep the witness from showing up. That's how they define procurement. I think that's a great definition.
Well, didn't the defendant act in this case? I mean, he lied to the police officer. That's an act. It's
not one, you're assuming that he lied to the police officer. That's an assumption, not a reasonable inference is my argument on that. And I'll get into that. But I also don't think that's an act by the defendant because he didn't do anything to keep the witness from showing up. They actually subpoenaed the witness after that.
Well, it's an act. It's just not directed at the witness.
I agree with what you're saying. That's correct. It's an act, but I don't think it's even an act to keep the witness from showing up. So if you're going to say he lied to the police officer that day, that's fine. I still think they don't meet their burden of proof under forfeiture or wrongdoing because that act it wasn't wrongful. He didn't do anything to keep that witness from showing up.
Aren't there cases?
Wasn't there some time frame? I mean, wasn't there some time between when he talked to the police officer, regardless of what he said to him, and when the subpoena was issued?
That's correct, Your Honor. On April 8th, I think it's also important to remember law enforcement go to Mr. Brown's home. He has an attorney and they start questioning him about a case and they're asking for his help to prosecute him, which is very strange and should never happen. But he answers the door. Keep in mind, they don't say who they are or what they're doing. They don't, according to the record, they just say, is Lori Hutzelman here? That's all they ask. And he says no. So to your point, Judge, about the time frame, April 8th, the investigators showed up to serve a subpoena, but they did not tell that to Mr. Brown. April 12th, they show up and serve the subpoena. So the subpoena actually did get served. In all the other cases that we have on forged for wrongdoing, a subpoena never gets served on the witness. And that's the main problem. They can't even serve the witness. In this case, they were able to serve her. She just didn't show up because she didn't want to. We have no idea. No one can say why she did or didn't show up. That's my whole point. Nobody knows.
Didn't she resist? Didn't she resist receiving the subpoena? Didn't she? I mean, she wasn't just greeting the law enforcement officers with open arms, number one. And number two, she said at the time that the offense was committed that apparently she'd gotten the daylights beaten out of her and choked and everything else. She said she didn't want to pursue it, didn't she? Isn't that what she said?
That's correct, Judge. That is true. She did shut the door. The way the facts go on the record, on April 12th, the investigator shows up. No one answers. He goes back to his car. She then answers the door and looks like she's wiping sleep from her eyes as she'd just woken up. He says, I'm here to serve a subpoena. She shuts the door in his face. He leaves the subpoena between the screen door and the front door and says, you've been served with a subpoena. And then that was Friday. She did not show up Monday, and the state did nothing to bring her to trial after that.
Wouldn't you say that plus her attitude at the time of the offense might give the state a little bit of an inkling that she might not be a willing witness and might not show up?
I don't know, Judge. I guess you're saying, could you make that reasonable inference? I would say that's an assumption and a guess because there's nothing in the record to show what the state knew or did not know about her.
What I'm getting at is under that scenario, I think maybe a reasonable prosecutor might think about getting an attachment, or at least ready to get an attachment.
That was my second part of the argument, Your Honor. They didn't do anything to bring.
I'm sorry, I didn't mean to preempt you.
No, it's fine. They did nothing
for you.
they did nothing to bring the witness to court. They showed no good faith effort at all. They basically said, we know she's going to be a difficult witness, so we'll just do it. We'll just try to show her out of court statements through her videos on body cam and let the officer testify because she's going to be hard. That's not the way it works. You have to make some effort, and the courts have said make some effort. And I think the two cases that have been briefed really hash it out for you, Reed versus Reyes. And I'll just touch on Reyes because you have these cases in the briefs. But Reyes, 3 days before trial, they try to get this guy. He's in Juarez, Mexico. They ask grandma for help. Grandma says, we can't get him. They give up. That's more than what our prosecutors and our district attorney's office did to get her to trial. And the court still said, not enough. That's not a good faith effort. Just because the state thinks a witness may refuse to show up doesn't mean you stop trying.
Counsel, I agree with that, but I mean, the other side of the argument though is, aren't we supposed to be looking at whether the trial court could have inferred from the evidence that was presented to it by a preponderance of the evidence that this defendant did something to prevent this witness from showing up? And I guess the question I have is, don't we have cases that talk about obstruction where You're talking about someone standing in the door saying, so-and-so's not here. You're in the wrong place. Isn't that something that we don't we have cases like that?
Your Honor, I'll touch on that point. It's a two-element problem, forfeiture or wrongdoing. The first one is the defendant did
I'm just
something.
talking about offenses, obstruction.
Oh, sure. Yeah, obstruction. That's exactly right. But there's no way of knowing if Lori Hutzman was in the house that day or not, because the question was, is Lori here? He said, no. Then they continued to question him. They didn't say, hey, you have a lawyer. This is a case against you. We're about to try you next week on it. We should go. They continued to question him. And I still don't understand where they're saying he lied. There's no evidence of a lie.
Didn't he say something about she has relatives in Ohio or something? I mean, something along those lines. But other than saying the word no, when you talk about preponderance of the evidence, just because he said no on the, what was it, the 9th or something like that, you know, I don't see, maybe I'm missing something, but I don't see anything on the 12th or you know, if he's trying to impede her being there, you almost, you know, if you're weighing evidence, you've got her at the time that the offense took place said, I don't want to pursue it. And then the other time slamming the door, not to get the subpoena. And that's what you've got. There's no evidence that he was there at the time the subpoena was served to intimidate her. I mean, if he'd been behind her with a gun in his hand or something like that, it might be entirely different. But what act do you have other than him saying, no, she's not here? Is that, and to say that that's the preponderance of the evidence that you can, that you're relying on, that he has some way blocked her being there.
Well,
Of course, it's a possibility.
He also said that they had broken up sometime before too, which is kind of not true since they're on Facebook together. So
Actually, that's a good point. I wanted to ask that question about the posting of the, what is it that indicates this picture was from April 1st? The picture of them being, was it because it was posted on April 1st? Does the picture suggest on it, is it printed like it was on April 4th, metadata? What do we have information wise that says the picture was taken on April 1st?
That's an interesting question. Nothing other than the Facebook post says posted April 1st. We have nothing to indicate when that picture was taken. Also, if you look at States Exhibits 2 and 3, which are the ones that indicate when they were posted, you can't tell who the male is in those screenshots. It's just you can't tell who it is. You take a look at it, there's no way of knowing. It's just a guy and Lori Hutzman, and it's posted on April 1st. And that's it. You have no way of knowing when the picture was taken, no way of knowing if it was just something she was throwing up on Facebook a year later, 10 days later, who knows? You have no idea. Plus, to your point, and the judge who just spoke, he did say they had busted up, but that was, what does that even mean? Who cares? I guess is my point. And my other point is this. I just want to be careful here, and I'm not calling the state out or anything, but in the state's brief, he said they busted up several months ago, but that's not the statement, and that is not what was said. If you look at the reporter's record, volume 3, page 13, the statement comes directly from there, and he just said, we busted up. That's it. So let's not add anything to this. We don't need to help Mr. Brown out in any way by adding facts.
Was there a request to issue a writ of attachment at any time?
There was never a question to issue a writ of attachment. Not once. Never did they ask to do that. Judge, after they served the subpoena on April 12th, they stopped. They did nothing else to try to bring this witness here. So I have 2.5 minutes left. So my point is this. He did no act. He didn't act in any way wrongfully to keep the witness from coming to court. She just didn't want to come, as Kiesler keeps saying. She didn't want to come. That's not his fault. Secondly, the state did
You right there. I do have a question about that. I'm wondering, because is there a previous family violence type of episode between these two?
There is, Your Honor.
So could that not permit an inference for the trial court judge that perhaps there's something going on in the way of intimidation that, you know, isn't, for example, supported by direct evidence, but circumstantially could be established?
Yes, Your Honor, that's true. However, all they did was ask the court to take judicial notice of a prior assault family violence. If you look at the case law, especially McGee, Schindler, and Garcia, which are all cases with forfeiture or wrongdoing that involve family violence, and even Giles or Giles from the United States Supreme Court, I don't know how to say it. If you look at those cases, they brought witnesses in to testify about the family violence and what it meant to her and how it might affect her. They brought experts in, they brought people from the Women's Center. All we have is someone taking judicial notice of a prior family violence. We have nothing to indicate that it affected her in a harmful or intimidating way. And the other cases have that.
Could these statements have come in under another legal theory, like non-testimonial excited utterances?
Your Honor, with all due respect, I don't know how these could possibly be non-testimonial statements. If you look, these are identical to the statements in Hammond. They are outside the presence of the defendant. She's separated. They're all past tense, and they are absolutely used as a replacement for testimony in court. They have to be testimonial.
Did the Court of Appeals even address that question?
Excuse me, when she says, I don't want to pursue this, that seems to be taking into account, at least to some extent, that there might be proceedings afterwards that she does not. So she's talking about testifying basically when she says, I don't want to pursue it. So it would seem it would be testimonial in nature. I mean, this is not, just a real prince of a fellow that beats up his wife all the time. But that aside, it would have been so simple for the prosecutor to say, let me get out an attachment. She's not here. And if there's nothing in the record to show that, just other than, well, she's not here. Well, that's enough. Well, it isn't enough. I don't think. Is it?
I agree, Judge. I think the case law supports you. My time's up. If you want me to answer that question, I will, but I don't want to go.
Right.
Thank you, counsel.
Thank you.
Counsel, you're muted.
Somebody's muted.
Yeah, we can't hear you.
Mr. Bonto is muted.
It doesn't show him muted, but we can't hear him.
We can't hear you. Can you breathe? Can you breathe on there?
Well, now it's not muted.
I just went. I think Mr. Guy is who you need to speak to.
Right,
We
Mr.
We
Can't
can't
hear
hear
Mr. Guy.
He's trying really hard.
Is he?
Effort. I'm sure it's also very eloquent too.
Oh, there he is.
Yeah. We can't hear you, Mr. Guy.
Someone is preventing him from speaking. Someone has procured his inability to speak.
Mr. Guy, you might need to change your audio source.
Now you're muted. Now you're not. I still can't hear you. Hey, is your audio? I mean, have you checked if your audio is working? Doesn't seem to be.
See if you can change your audio settings.
Hopefully, is it a situation where the host has him muted even though he's not?
Doesn't look like it because
Judge, he's unmuted. We checked his audio before the oral argument started and it was working at the time, but I'm unsure what's happening now. I'm chatting with him to try to figure it out. I apologize.
I blame technology.
We're going to have him call in. He should be calling in just a moment.
Okay.
Well, at least his time hasn't started. That would be unfair. He is entering via phone right now.
Can you hear me now?
Yes.
All right. I'm going to try to put on speakerphone. Can you still hear me?
Yeah. Uh-oh.
All right. I'm going to take it off speakerphone.
Mr. Guy, you'll need to turn your audio off on your computer. That's the feedback from your computer audio.
All right.
He's done that.
Okay. I've muted the speaker on my computer. Yeah. Can you still hear me?
Yes.
Okay.
Great.
All right.
You should also be able to put it on speaker now.
All right. All right. I've got it on speaker. Am I coming through clearly?
Just
Yes.
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 All right. Well, not the ideal way, but
you have handled it with grace
now,
sir.
Yeah. May it please the court, Mr. Botto. In evaluating Article 38.49, there's basically two key elements that have to be considered. That the burden of proof for showing that there were bad acts from the defendant that caused the witness to be unavailable is only by a preponderance of the evidence, and that it's judged by an abuse of discretion standard. So that means it requires a relatively low level of proof of the defendant's acts, and the ultimate question is not whether the court necessarily agrees with the trial court's ruling, but just was the trial court's ruling within the spectrum of reasonableness.
Well, isn't it? When you talk about by preponderance of the evidence, that's it's more likely than not.
Yes.
Basically. And so that's what we're looking at here. If the judge abused his discretion or didn't do so in finding that this was an act that purported to restrain her from appearing as a witness. So that's more or less that it's more likely than not under the evidence. If we find, if we were to find that, well, it doesn't get there, then you're out of luck. If we say, well, no, it's reasonable for him to assume that from evidence that's there in the record, rather than pure conjecture, right?
Right, and that's the key point, Your Honor. That the question is it reasonable for the judge to think it's more likely than not? Not necessarily that you agree that it's more likely than not, but could a reasonable person have thought that on these facts?
Exactly.
And the state would contend that the answer to that is yes, it was reasonable for the judge to feel this way.
Counsel? Can you hear me?
Yes, sir.
Yeah, I was gonna ask, one of the things I'd ask the opposing counsel is this definition of procurement, and when I look at what we're supposed to look at to determine what procurement means in this statute, and looking at the cases dealing with forfeiture by wrongdoing, it seems to me that it's not, as appellant argues, that there has to be just an overt act, but there has to be an overt act against the witness. And what overt act do we have here, or what do we have to point to in the record that shows that this defendant committed an overt act towards the witness that was designed to prevent her from testifying?
Well, Your Honor, I would dispute that the overt act necessarily has to be directly against the witness. It just has to be to keep the witness from testifying. I think the Schindler case out of Fort Worth that was cited in my brief.
Doesn't in that case he threaten the witness?
No, Your Honor. In that case, the overt act in question was him blocking the police off when they showed up at the residence to serve a subpoena on the witness, and that, coupled with the prior evidence of domestic violence between that defendant and that victim, what was enough to meet the preponderance standard. And that's essentially the same fact pattern we have in this case. We have a prior history of domestic violence between this defendant and this victim. And we also have the defendant taking an overt act directed against the police, as in Schindler, to keep the police from being able to effect service on Ms. Hutzelman. Now, several of the court have indicated the fact that, okay, they weren't able to serve her. Weren't able to serve her on the 8th. That doesn't mean that they couldn't come back and serve her later. And in fact, that they did serve her later. But I think, as with Schindler, the relevant fact is the fact that the defendant would act in that manner to obstruct the police from being able to serve a subpoena makes it reasonable for the court to infer that he would take similar actions against the victim to dissuade her from testifying. And that's why in Schindler, that single act of obstruction plus the violent history was enough to meet the preponderance, even though theoretically the police could have come back at another time and tried to serve her when the defendant wasn't there. But that's
Mr. Guy, go ahead. I'm sorry.
Why no writ of attachment?
Yeah, that's what I was just going to ask.
Well, and there's two essential points on that, but to answer your question first, a writ of attachment isn't required in a forfeiture by wrongdoing situation if it would have been futile. And in this case, I think there's good cause to conclude that seeking a writ of attachment would have been futile. The state's previous efforts, it took multiple attempts to even locate the victim. There was active obstruction from both the defendant and from her. When the police got there, or when Investigator Rivas got there, she wouldn't even open the door to the officers to speak to them, which obviously for a writ of attachment to be effective, it's not going to be sufficient just to drop a paper off. You're actually going to have to get physical control over them. And
Counsel, do we consider the acts of the victim in determining whether there's been wrongdoing?
Well, certainly the fact that the victim did not ultimately show up, it would be a relevant factor to consider. And when coupled with the defendant's history of violence, with his specific acts to keep the police from getting contact to her, with the evidence that he clearly had ready access to her from the fact that he was on several occasions seen at the same residence that she was located at. And so on the wrongdoing side, I think that the fact that she didn't show up at the end and is certainly a relevant factor to consider.
I'm sorry. Do you agree with Mr. Boto that there was a confrontation clause objection at trial?
Partially. I believe there was a valid confrontation clause objection as to whether the defendant had committed the misconduct or not. I do not believe the defense validly raised the issue concerning the state not seeking a writ of attachment or that the state had failed to show that it had exercised reasonable efforts to secure the witness. The record
once a confrontation clause objection is raised, whose burden is it then to demonstrate those things?
Well, I believe when a confrontation clause objection is raised, you still need to be specific about the nature of how that's being raised. I would analogize it to the Resendez case where the defense objected under Article 38.22, just making a global objection, and that was deemed insufficient to preserve a specific objection within that the police had not satisfied the Miranda requirements within 38.22.
Well, excuse me, though, but the confrontation clause has to do with, at least in the context of this case, with the statements, the hearsay statements that were brought in without the person there to confront the victim in the trial. And is there any doubt that what she said was testimonial? Really?
Yes, Your Honor, I would dispute that, because there is precedent from several courts that when police officers first arrive at a crime scene, when they're making the initial contact there in a domestic violence situation, that the initial statements they get are not being taken for the purposes of building a case against the defendant. They're there for the officers to ascertain the situation, determine what's going on, what measures they need to take for their own safety and for the safety of the people at the location.
Did the Court of Appeals address the testimonial nature of the statements? Was that an issue that they reached?
It was raised by the state in our briefs. I do not believe the Court of Appeals took that issue up, because they basically decided on the confrontation clause grounds, and so they didn't need to address the testimonial issue. But if I could return to the issue of the defendant's failure to properly preserve the claim about the state not seeking a attachment.
Excuse me, before you go there, on the question that Judge Urey asked you, did you look at Tavares Moore, which was actually out of Gregg County and went to Texarkana several years ago, that clearly said that these kind of videos are testimonial?
Well, again, Your Honor, that's always going to be a very fact-specific determination. And in this case, the facts show that the defendant was still at the scene when the officers arrived there and took these statements. The victim was still in an excited, agitated state because of that.
Excuse me, those facts were exactly the same in Tavares Moore. I'm very familiar with it. I actually tried the case.
Well, in that case, Your Honor, I'd say that's why we're at a higher court here, where that can be considered. And the state's contention is that there's good cause when the officers are responding to a domestic violence incident, when they're first at the scene, that the statements are non-testimonial in nature, because they're not building the case at that point. They're just securing the scene. It's basically the conversational equivalent of a protective sweep. They're trying to find out what happened so they know what they need to do to safeguard themselves and the people at the scene, which is what the officers were doing at the point when they took those statements. And thus those statements would not be a testimonial statement that was gathered to help with an eventual criminal prosecution, but was a statement that was taken just so the officers could know what was going on and what they needed to do to maintain the safety at the location.
Okay, thank you.
Yeah. Now, so again, to return to the issue of the defendant not properly preserving the issue, the entire purpose of making of requiring a specific objection is so the trial court can address that issue at the time. If the defense had objected at that point, not just on the grounds that they were contending that the state had not proven the misconduct by the defendant, but had also raised the issue that the state had not done enough to secure Ms. Hutzelman's presence at the trial, the court could have taken corrective action at that time. The court could have instructed the state to get a writ of attachment. It could have asked the state to document for the record why it didn't believe a writ of attachment would not be effective in this case. Corrective actions could have been taken, which is exactly why we require a specific objection. But the defense didn't make that specific objection. They didn't raise any issues about the state's efforts to procure Ms. Hutzelman. The defense's objections were only about whether the state had adequately shown that the defendant had engaged in conduct to keep her from testifying. And because of that, the state would contend the defense did not preserve any claim on the on whether the state had shown she was unavailable or not, and thus should be barred from raising that issue on appeal. Now, in the alternative, even if the court does not agree with that, the state would also still contend that a writ of attachment was not a realistic remedy in this case. As the court can see from the trial record, this was a very short trial. Even with the Ms. Hutzelman's out-of-court statements being permitted, the guilt innocence portion of testimony only lasted not even a full day. Cut that section out of it, and the length of the trial would have been probably not more than an hour, which, given the prior history of both the defendant's obstructions and Ms. Hutzelman's obstructions, it's just not realistic that the police could effectively, serve a writ of attachment at that point. It's not even clear where they would have gone to serve such a writ. The legal authority of a writ of attachment to go into a private residence is unclear. I haven't been able to find any case law that clearly says a writ of attachment even authorizes the police to go into a private residence. The closest I found one case where officers did enter a residence with a writ of attachment, but they also had a search warrant for the residence at the same time. So the search warrant would have given them that authority. But even if we assume that a writ of attachment gives the police the same authority as an arrest warrant, the officers would still have to have good cause to believe that the person they were looking for is in that residence before they could even enter that. In this case, at best, what the officers would have is that Ms. Hutzelman had been seen at that residence three days before, which isn't necessarily good cause to justify the rather extreme action of entering a private residence when there's no more current information about her being there. So realistically, before a writ of attachment could even be effected, the officers would first have to even figure out where Ms. Hutzelman was located, something that's going to be very...
Excuse me, but I'm going to be nitpicky here. You claim that the defense failed to object about that the state had failed to show that the victim was unavailable. But the defense did object to the use of the out-of-court statements based on the grounds that the state had not proven the appellant committed any misconduct to keep her from testifying. And when you look at the statute 3849A, it says a party to a criminal case who wrongfully procures the unavailability of a witness. So if he's objecting on the basis of the statute, unavailability is part of that statute. So how many times does he have to object about unavailability?
Well, Your Honor, that's where the Resendez case that I referenced cited, which was 306 SW 3D 308, and the specific relevant portion on 313 of that. And in Resendez, the defense objected on the basis of 3822, just making a global objection, and this honorable court concluded that global objection was not specific enough to preserve a subsection objection within 3822 and the provisions within 3822 that required the officers to have properly Mirandized a defendant before taking their statement. And essentially, it's the same situation in 3849. Just the global objection by itself doesn't preserve the specific claims within it, because 3849, there's a couple of different things in it that such an objection could refer to. That's why we need a specific objection in this case, or at least context to show that the defendant was arguing both prongs of 3849. And in this case, the context shows the exact opposite, because Mr. Owens' argument at trial was all about whether the state had shown bad acts on the part of the defendant that kept the victim from testifying. At no point did he ever make any reference to the state having not taken sufficient measures to ensure that she would be present in that case. And thus, just as in Resendez, a global objection was not enough to preserve the specific Miranda subsection objection, so to hear a global objection under 3849 in the Confrontation Clause would not be enough to preserve the sub-issue of whether the state had taken sufficient steps to ensure the availability of that witness, absent a more specific objection on that specific point.
So the entire debate at trial as to whether he did something to keep her from being available, that's not enough.
That's enough for the first half of 3849, the issue of the misconduct. It's not enough for the state's efforts to secure that witness. That would need to be raised separately, just as the different subsections in 3822 would need to be raised specifically, just as I believe with a Rule 403 objection, it's necessary to articulate which of the various ways 403 can be violated are at issue. Because again, it gets back to the whole reason why we require specific objections is to give the trial court the opportunity to address that claim. And it's not the trial court's responsibility to make arguments for the defense. The defense itself is not advancing. And in this case, the defense at trial did not advance the argument that the state's efforts to secure that witness were insufficient. Again, if they had, the trial court could have taken up that point, could have maybe corrected this at that point and resolved this issue then. But that argument wasn't made at trial, and thus it shouldn't be allowed to be processed on appeal.
Let's get back for a minute to just the evidence of some act that was taken to prevent the witness from testifying. I mean, and I think you make the point that I think that the trial judge's findings of fact are due a good bit of deference. Those determinations really need to be supported by the record. And I think it could be argued here at least that there's just simply no record-based indication that Brown actually did anything to keep her from testifying. I mean, he may have temporarily kept her from being subpoenaed, but she was ultimately subpoenaed. And then, that's the problem. What you've got to have an act that goes to preventing her from appearing. And I mean, we got the fact that she's not there, but what is the first thing, as a prosecutor, what's the first thing that you do or should do when you got an inkling that you got a witness that doesn't want to be there and doesn't want to come in for whatever reason? You do make sure that you got them there.
And it's not just a witness, it is the witness.
Yeah. And so that's, all it takes, he didn't have to know that he's gonna get them, but at least you take all the steps necessary. And it seems like to me an attachment, it would have been so easy, and do it in advance. If you got an inkling somebody's not going to be there, by golly, make sure they are.
Well, Your Honor, and you have several questions there, so I'll try to get them all. But to address the last one first.
I didn't mean to be multifarious.
Oh, no problems, Your Honor. In terms of the attachment, while theoretically the state can pursue to have a victim of a crime essentially put into custody before trial, just on the concern that they won't show. In practice, that's a pretty extreme action to take. I mean, just we saw in Harris County in the last election cycle, that was basically the dominant reason the incumbent DA got voted out there, because the citizenry was upset with them for arresting a rape victim that they were afraid was not going to cooperate. That's a measure that you really need real strong justification to pull the trigger on preemptively arresting someone. In this case, just a person being difficult at the door, I don't think gets you to that point. It's there's plenty of cases where a witness is uncooperative, but does ultimately abide by the subpoena. And in this case,
but doesn't that go back to Judge Keesler's point, which is if a person arguing at the door isn't really enough to justify a writ of attachment, how can you then say that it is bad enough to justify the whole forfeiture by wrongdoing?
Well, at the point of the attachment, at that point, it wasn't known that she wasn't going to cooperate, though. I'm basically talking about a preemptive writ of attachment here. At that point, still, we didn't know that she wasn't going to actually abide by it. The fact that she didn't show up then gives context to everything else, and that, coupled with the defendant's prior actions and lying to the police, his prior history of violence towards her, the fact that he clearly had ready access to her and had a strong motive to prevent her from wanting to come in and testify. All those pieces kind of click together at that point, and you show that, oh, wait, okay, now it's clear what is going on, that he is discouraging this witness from testifying, because he has actually succeeded in getting her not to come, which follows from his prior actions. Now,
Counsel, I hate to interrupt you, but we are on a tight time schedule and your time is up. Thank you.
Thank you, Your Honor.
Thank you, Your Honors. I will start. I want to start on the piggybacking Justice Hervey's comment about when you make the objection to the Sixth Amendment confrontation clause, and then you go to a forfeiture or wrongdoing, you have now specifically objected to both elements, that there was no overt act and that they did not procure her availability at trial. They didn't the state did not make a good faith effort to get her to trial. I also want to talk about what the state could have done in Gregg County, because this is the way trials go in Gregg County. You pick a jury Monday morning, you start the trial Tuesday. The judges do not swear a jury in until Tuesday morning because of issues like this. They give the state the opportunity to go out and seek those witnesses. In this case, the subpoena that was served on April 12th requested Lori Hutzelman to show up on the Monday morning. When she did not show up, and the reason we do that in Gregg County is so when they don't show up on the Monday morning, we can then ask for a writ of attachment, and we can use the Special Investigations and Apprehensions Unit. We can use confidential informants, and we can go out and try to find these folks and under a writ of attachment, bring them into the courtroom. That's why the trial doesn't start until Tuesday morning in Gregg County.
Great.
They had
what is this case distinguishable from Schindler or not?
Yes, that's my next point. Schindler, the investigator did not go up to the house in Schindler. The investigator was waiting on the street. The defendant went out to the investigator's car on his own volition, his own act. He went to the investigator and blocked the investigator in his car at the same exact time that the witness drove out of the house and ran away. And he told the investigator, if you want her to show up, you will have to arrest her. You have to couple that with the other facts in Schindler, where she gave an information to the police officers. It maybe it's a checklist form, I don't know, where it says he's aggressive, he has suicidal tendencies, he's mean to the kids, he can't keep a job, he does use drugs. All that's in the Schindler case. We have no evidence of that.
Threatens her.
And he threatens her. And he threatens her on multiple occasions, and she was scared of him. All that is in the Schindler case. We have no evidence of that in our case. And I'd like to also address the Espinoza case, because the state relied heavily on Schindler and then in their brief on Espinoza. But in Espinoza, you have recorded jail phone calls of the defendant calling the victim witness, saying all these things she had to do, especially saying you need to stay low, keep it low key and stay low key, which is exactly what you had in Garcia. You have direct action from the defendant toward the victim witness, threatening them and keeping them from coming to court. You do not have that in this case, and the state did nothing to bring them to court. Just one more point on the futility. The state just said, because she closed the door in the investigator's face on April 12th, it would have been futile to seek a writ of attachment, right? That's what they said. But then they're also saying, we didn't know if she would show up or not. So why would we seek a writ of attachment at that point? I don't know how they can have it both ways. He's asking to have his cake and to eat it too. If that conduct then shows it would be futile to seek a writ of attachment, it can't then also be like, we didn't know she was going to come. You can't use it both ways. You cannot. All I'm saying, and I'll end with this, I think the Constitution of the United States was ignored in this particular case with this particular fact pattern. And we'd like to get it right through this court. Thank you for your time.
Let me ask you this question though, before you go. You mentioned the Monday and Tuesday of trial. At any time on Monday or Tuesday, did the state ask for a continuance to get time to get the person there, the lady there? Or did they just want to do it with the videos?
Exactly, Judge. They never asked for continuance. They never said, Judge, we need time. We need to track this witness down. They always wanted to do it. And I don't mean to say it this way, but the easy way. We got a police officer. We got body cams. We think we can trample on the Constitution of the United States, and we can present evidence in a way that should never be presented in a courtroom. And that's what the state did.
Thank you.
Thank you, counsel. The case is submitted and the court will stand in recess until 10 o'clock.